Mede nchia sonko enema daily trends etiefo nyina yedama se de da ne da nyina mo hwe yen na mo like na mo share sabre ensem a editie abeka yensa yemonura ensem no emu
menemo kasei the Ghana Prisons Service car eba Accra High Court assign Eddie Chairman Bernard Ntwiposi akon ya dodo na fe the chairman want to me akon back to prison custody because ene na owo asem ewo the Accra High Court Division 13 Division 14 na ne summer boy case ne wa Justice Audrey Okovite a sentence Chairman Ntwiposi akon into 20 years imprisonment with hard labor. In fact, what shall see or serve ne term ewo the Nsawam prison. And that case no the Tano Numeri Forest case. And I was another case the Ezim Bank case into 3 different cases. And this current administration a press editor chairman want to be of which one of those cases has been judged. Na lawyer niya na ojinamu edema chairman Bernard Ntwiposi akon ewo the summer boy case say yedi ruling na babontin ya learned lawyer Atachia. Interestingly, during the day of the delivery of judgment na lawyer Atachia eni oman yimo or the summer betu dwase na was attended the graduation ceremony of ne baba na just a date na aye fix that na oye ho hwia enye ye. But in all this na lawyer Atachia a file 2 applications ewo High Court and a Supreme Court. Ni nyina no Justice Audrey Okovite a boss applications in nyina tugwe e deliver the judgment. Application number 1, lawyer Atachia chiremwa some clauses within the Mining Act no ehia say nchechiremu beba na nchechiremu no ba yi a it is going to affect the judgment judge ni no ede baba bontin into no refer the interpretation at the ama Supreme Court. And our the application court to High Court to say one High Court and defer judgment because the interpretation of those clauses no very very crucial to asema ye kan. 2 High Court and sign and suspend the sitting because it was said or no as a lead counsel present na o move motion no but unfortunately oni ho. So application in no Justice Audrey Okovite ebo edi tugwe na o deliver the judgment of finding chairman would to be guilty on all 6 counts or sentence no to 20 years imprisonment. Assign a man 10,000 fine unit yana amount to some 120,000 Ghana cedis as fine together with the 20 years imprisonment. The NPP through the flag bearer Dr. Mahmoud Bawumia convey an emergency meeting with the legal department of the party led by lawyer Frank Davis. There were lawyer from Penny Fort is a lawyer Gary Nimako, former Attorney General Godfred Yeboah, Deputy Attorney General Alfred Tuan Yeboah, another Deputy Attorney General Yamame Asonaba Dapa, lawyer Ejay Bafwa, Member of Parliament Dema Menshia, lawyer KT Hammond, Yura Kojo Ponkroma and associate here and also or no lawyer Kojo Ponkroma, lawyer Kwesi Botwe, and a host of others. Omotra Seno and Omo Yamaju said Debbie. Judgment no abano. Nyama bebrebe wo mu a according to them enemra ebabra entino there should be an appeal. Eno mojitu mu. Enra na lawyer Atachia every amanone ebedro mayi. Lawyer Atachia se o transe se o hwe judgment Justice Audrey Okovite editu dwam. Wotumia identify 20 grounds ye chese judgment no juma enye. Sansuna other lawyers are omo constitute the MPP's legal team. They said the former Attorney General any also the group of lawyers Alfred Tuan Yeboah Mame Asonaba Dapa so say omo so identify certain errors omo dey support to the appeal. Ya tenso dey free yewra Kojo Ponkroma and associates on also group of lawyers number over 20 omo chirema omo so nyabre judgment ni mu also identify certain errors ebeboa in the appeal. Afei lawyer Kwabena Tahir Hammond enso ene ne law firm enso identify bi enti no lawyer Atacha de nkwa ne 20 according to him. Bebo vote video no any audio ni according to him 20 and as say oba identify. The nyina put together no Chere said there is going to be a very, very, very strong appeal defense from the new patriotic party's legal team. Interestingly, let me chip in this before and say I'm about lawyer Atachia audio ni actually. Interestingly, the appeal a united front led by lawyer Atachia. The lawyer Atachia is the lead counsel for Chairman Wontumi Tonu ne lead. But the former Attorney General, any associate, lawyer Kojo Ponkroma, any associate, lawyer Frank Davis, any associate, lawyer Gary Nimako, any associate, after season lawyers, this is lawyer KT Hammond. And no more come back this particular appeal. It's a yes small appeal. May I say it is going to be a historic precedent over the Court of Appeal involving this particular case. Enti yanko na yanko tie lawyer ni panyin lawyer Atachia enra ofiri amano ne bae na oni enuanom Joy FM4 edi nkomo ensam kakra odi etudwa coupled with this piece of information me dey abrel going forward what we should expect from the appeal on judgmental Justice Audrey Kukovite deliver on Chairman Bernard Chibusiakon the Summer Boy cases.
There, Mr. Thatcher, you've already mentioned that you are going to collaborate with your party, the MPP, to file the appeal processes. If the Court of Appeal should uphold both the conviction and the sentence, are you prepared to take the matter to the Supreme Court?
Definitely. In fact, we will exercise our rights under the law that when you lose in the High Court, you can appeal to the Court of Appeal. And when you are not, happy with the decision of the Court of Appeal, the court of last resort is the Supreme Court. So we use all the arsenals that we have to ensure that we get justice.
You have already mentioned your reason for being absent on the day of judgment, but looking back at the conduct of the trial, do you think there is anything your defense team should have done differently, or you're convinced the outcome resulted solely from the errors by the court?
Well, you see, I wouldn't want to do a post-mortem of what the previous lawyer did and what I did. But what I can tell you that when you look at the entire evidence as I inherited it, and the fact that I raised constitutional issues for the consideration of the judge, and he ignored it, and graduated the High Court into a Supreme Court, I can tell you that that's an aberration of justice, and we'll find our day in court.
There are those who also argue that you took this case during its twilight and that there's not much you could have done to defend Chairman Wontumi. Do you think this could have been one of the reasons why we witnessed the judgment that happened yesterday?
Well, I can tell you something which is very, very consequential, which is that I didn't start the whole case, and every lawyer has his own style. But looking at the poverty of the prosecution's case, and I will stress that, I've given you some hints. I do not see how this judgment is founded on law and evidence. Because for the world of me, I can't believe how those who are supposed to be charged, and then they get them to come and testify against the man who gave them the opportunity to go and do the reclamation on the land. Do you think they'll be able to tell the truth? Is it not an insurance for their liberty? So these are serious matters that we don't want to take for granted. Today we're talking about an assignment of a mining right on whose mere say so. And the man has not said, look, can you give me 250,000 United States dollars and I give you the concession? They didn't testify to that. They never said even they wanted the money from them. They said, go and do the reclamation. When you do the reclamation, try as much as possible to do coconut plantation on the reclaimed land. If the people were wayward, the two individuals who became the prosecution witnesses were wayward and they went on illegal mining, where is the mens rea in this matter? How do you want to attribute the criminal activities of the two individuals to Chairman to me? These are serious matters. You're talking about circumstantial evidence as the pivot of this your decision, because there was no direct evidence that there's a mineral rights transfer. And we have been educated that circumstantial evidence should lead irresistibly to one conclusion.
But many would argue that he allowed that to happen because the concession ultimately belongs to him.
Of course. So when you have a farm and you get hirelings to go and harvest cassava or do something on the farm, you understand? Does it mean that you have assigned your ownership of the farm to them? The absurdity is monstrous. How can somebody say that if somebody is working on another man's concession, that is tantamount to assignment of mineral right? How does it happen? I don't get it. And meanwhile, the so-called prosecution witnesses never testify that the man has assigned the mineral rights to them. They never said so. So how can he be convicted? These are serious matters and they are very consequential. So we won't give up.